Good afternoon. Welcome to today's webinar, Electronic Medical Records and Coding, Keys to Correct Coding and Compliance. In 2007, the Department of Health and Human Services and the Office of the National Coordinator for Health Information Technology published an extensive report on recommended requirements for enhancing data quality in electronic health record systems. The section that reviews evaluation and management documentation, features, and analyzes current certification criteria for these EHR features, that EHRs provide a variety of tools that enable a provider to be more efficient when documenting an encounter. These tools include the use of defaults, templates, copying, and others. The report then continues with the warning. These tools can be extremely helpful if used correctly. However, the tools can also open EHR systems up to fraud or abuse. During this one-hour program, our presenter will briefly present an historical overview of electronic medical records to demonstrate its inevitability and purpose, identify potential EMR compliance risk with EMR coding, emphasize key documentation integrity principles and practices in the use of an EMR, and unveil the Office of Inspector General's focus on entities using EMR, and reinforce the goals and objectives of an electronic medical record system. The presenter for today's program is Mary Falbo. Mary is a certified professional coder and the president and owner of Millennium Healthcare Consulting Incorporated, a national healthcare consulting firm that provides billing, coding, auditing, education, and compliance solutions to healthcare providers. Her team of clinical coders experience includes evaluation and management coding, ICD-9 coding, Medicare regulations and billing updates, and other coding topics, fee schedule analysis, billing and collections, and claim denial analyses. The firm also produces customized nuts and bolts compliance programs to practices in response to the Office of Inspector General's compliance guidelines and special fraud alerts and identified risk areas. She conducts numerous coding and profitability seminars for law firms, pharmaceutical firms, professional healthcare societies, hospital health systems, and accounting firms. We will take 2 question and answer breaks during today's webinar. If you have a question, please use the Q&A or chat feature found on the right-hand side of the screen to submit your questions to the presenter. We encourage all attendees to submit questions throughout the presentation. Tomorrow morning, I will send out an email with a link to the archived recording of this webinar, and we do ask that you take time to fill out the survey that will appear on your screen after today's program is over. I now invite you to sit back, relax, and enjoy. I'm going to turn the presentation over to our distinguished presenter, Mary Falbo. Mary, the presentation is now all yours.
Thank you, Matt, and good day to all of you. I appreciate your time, and I hope within the next hour I will have met some of your goals or expectations in listening into my presentation today. And as Matt has mentioned, please, if you have any specific questions, I welcome them, and should they require further research, I'd be very happy to do the research for you and email Matt, who can then email them to you. As Matt said, my goal today is to basically talk to you about EMRs and coding. And our viewpoint, our spin is from the clinical perspective. The majority of us are nurses, clinical certified coders, and we work with a lot of hospitals, health systems, attorneys in representing physicians against payer probe reviews, Medicare probe reviews, or just normal prophylactic annual compliance programs that a lot of these large hospital health systems may have in place. So what I hope to enlighten all of you is our clinical viewpoint and some of the documentation vulnerabilities with the use of EMR today, so that hopefully you can bring that viewpoint and communicate the same language to your physician clients and or other appropriate personnel within your client structure. Again, the data here is current as of today. It is based on the American Medical Association documentation guidelines, and my valuable resource is AHIMA, the American Health Information Management Association. We use them as the gold standard in assuring that the electronic medical record meets the documentation integrity and helps minimize clients from potential fraud and abuse. As Matt mentioned, these are the objectives that I hope to accomplish within the next hour. And before I begin, it's like anything else in any given industry. There are a lot of acronyms that get used constantly, and it becomes alphabet soup after a while. But just for sake of clarity, I'm going to talk about the electronic health record, or EMR. But you may find that I will use the terms interchangeably. But basically, an EMR is basically an electronic medical record that's created, gathered, and managed by physicians in one healthcare organization. So it may be in a private practice. It may be just within a group of a physician network. The electronic health record is the EMR, but it then conforms to nationally recognized interoperability standards so that it can cross more than one healthcare organization. So you may have one medical center who has an EHR that can talk to the Mayo Clinic or another healthcare organization. That's the difference, is the ability to cross more than one healthcare. But for sake of today's discussion, what we're focusing on is that electronic medical record. Well, we know that, CMS basically has said, hey, EMRs are the inevitable next step in the continued progress of healthcare that can strengthen the relationship between patients and clinicians. And basically, the data, the timeliness and availability of it will enable providers to make better decisions and provide better care. Because not only will the record be legible, and you'll hear me repeat this, that the electronic medical record is really supposed to just mimic the handwritten note, only it's legible. And you'll see some of the documentation integrity issues that have evolved with the use of EMR. So with that legibility intact, hopefully the intent is that it would reduce incidences of medical errors, but so most often checking on medication errors and drug interactions and just handwriting legibility on dosage. So this has become a benefit, and hope that all these steps may help to reduce the risk of malpractice. It makes health information available more timely, so that not only will it reduce the duplication of tests if your primary care is ordering a Doppler echo and sends you for a cardiac consult, hopefully that cardiologist will have access to the electronic medical record and say, gee, Matt, I saw that you had this done 4 months ago. Let me just get a copy of it. It will decrease treatment delays. With the access of labs and data, hopefully there is more timely intervention in some of the chronic disease management so that the healthcare costs will be minimized in terms of managing chronic diseases before they become more severe. So we'll see, so we see the clinical value, okay, all around. So it does increase patient safety if used appropriately, improve quality of care. There's greater efficiency that will result when the right elements are brought into the mix. So the accurate, complete, and fast clinical documentation is key to patient care, as well as the reimbursement process. We also find out that it's basically inevitable. Not only will Medicare by the year 2013 have financial penalties, instead of practices being reimbursed at 100%, they will be reimbursed at 98% or 97% of the physician fee schedule, so there's financial penalties at stake. And President Obama issued the financial incentive up to $44,000 higher if you're in a rural area, to adopt a meaningful use EMR. And again, meaningful use is outside the scope of today, but basically, hey, is there an active medication list? Are you really using the electronic medical record, and is it an active, viable document today for your patient care? And basically, it's inevitable. When I go and work at some of the other physician practices, you have the younger physicians that come out of their residency. You know, a lot of us have children or relatives that, you know, it's in their DNA. They were born with that technology when they're 10 years old. So, you know, you have these physicians that are coming out of residency. They really don't want to go to a practice that's on a paper-based system. So in order to recruit some of the top-notch physicians, it is really fast becoming a critical recruitment tool for these new physicians. So we know they're inevitable for a multitude of reasons. We know the clinical value, okay? But then with anything else, there are areas of concern as it gets adopted because it's a new and emerging area of the business side of medicine. And there's still it's still a work in progress. It's in its infancies in terms of the standardization of the EMRs. So while, you know, I'm going to bring to light some of the coding documentation and compliance requirements and what we look for in order to attest to the validity of the EMR, you will also see that there are the same legal challenges that you face, and I will bring some of the feedback that I see that hopefully will become opportunities for, you know, you as lawyers to potentially help your clients, because what we see is that, you know, in the implementation of the electronic medical record, very little, in some instances, thought is given to, hey, can this medical record withstand a challenge to their validity in court? If subpoenaed, is it a legal medical record? Because we know that a medical record, paper or electronic, has a set of requirements for basic business purposes. So while there are well-established set of rules for coding, documentation, payer requirements, accrediting agencies, there's a gap in whether or not an EMR can withstand, again, the challenge of their validity in court. Now, in some of the electronic medical record vendors, any vendor that you know will say that they have that CCHIT certification, that CCHIT, is very valuable because CCHIT certification requires EMR amendments be recorded with the date, time, and author. So we have that audit trail. So we always say, hey, that's a requirement. And by the way, you really should run your EMR vendor and your specs by your respective healthcare attorney, because there are a few other requirements you need to consider, and I'm going to discuss them momentarily. So with the EMR, basically, oh, pardon me here, I apologize. To go back to the slide 8. With the EMR, there are 4 areas of concerns. There's the documentation integrity, and that's very big for us as clinical coders, and also to comply with the CMS and AMA documentation guidelines and the OIG's issues on fraud alerts. We're going to, you know, there's issue with automated insertions of clinical data and visit documentations using templates and the abuse thereof. Authorship, very key, and it's going to, and as you can appreciate, very key in the legal environment. The integrity of the borrowing of data from the nurse, from a resident, from a previous record, okay, and the issues of authoring past or current documentation as his or her own documentation. So we caution physicians on that. The use of scribes. Auditing integrity, what we talked about with something is corrected or amended or deleted or added. You know, is there the appropriate auditing and integrity checks to correct an error, to add late entries, to make amendments on a plan of care? So those are really important audit trails that we also look for. And then lastly, the patient identification and demographic accuracy. because a lot of this is automated demographic or registration entries, particularly in the emergency room. You know, a lot of the data gets populated in. There's erroneous patient identification with be it the same name but different middle initial. So not only does it lead to patient safety and quality of care issues, but there's potential HIPAA violations. So these are the 4 core areas of concern regarding the electronic medical record, and AHIMA addresses this nicely, and they become the core essence that I would recommend as attorneys that you focus in on as you work with your clients. So if we take the first one, the documentation integrity issues, okay, they basically involve either one or all 4 of these interrelated areas. The integrity of the clinical information recorded, and I'm going to show you an example. Typically, we may see that a patient is coming in for hearing loss, and then we go down further in the other portion of the history portion, and there's pertinent organ systems that a physician needs to review, and it says hearing normal. So there's inconsistency in the clinical data, because unlike the handwritten progress note, what happens is, and we all are guilty of that even with use of computers, it's very easy to get point-and-click happy, and there's a danger of electronic medical records that if a doctor clicks on a pertinent normal within a given organ system, that it auto-populates and fills in all the rest. So not only does it open does the integrity of the documentation become questionable, but now there's other areas of fraud because the doctor really didn't document that, didn't really do that, okay, didn't really perform that service. So these are things that are important for the doctor to realize the implication of using all these shortcuts, okay. The usability, the quality of the clinical care and workflow. You know, we have a lot of the specialists that say that the credibility of the actual electronic patient record is questionable when, one, they receive a progress note that's 5 pages long for a patient who came in for a sinus infection or an upper respiratory infection because he or she brought forth all this data from a previous encounter that's not relevant to the immediate plan of care. Then it becomes so burdensome and lengthy that the specialist says, I just want to get to the bottom line. What is, you know, the patient, what's the current status of the patient's condition? What's your treatment, your plan of care, your intervention? And so that's the one thing. Then the one inconsistency, for example, that I just gave you on the hearing, the specialist will say the same thing. They read the history, then clinically, you know, where they took the history taking, there's noted inconsistencies in the exam, so the clinical relevance of the history and exam has been diluted or questioned because the specialist has seen inconsistency and will say, oh, this is a typo error. And so he or she has lost credibility in that note that primary care may have done. If it's not structured, abnormal findings are embedded in the lengthy note that that it may be missed. So you're getting the point here on this documentation integrity. You know, again, we try to drive home. It should look the same as your handwritten note. If it was a half page, it's a half page. On electronic, the only difference, it's legible. And we now say, you know, you've heard the expression, if it's not documented, it didn't happen, okay? Well, there's a new mantra that's out there. Just because it's legible doesn't mean it's intelligible. And that's where we're finding, because there was a point where we could read the clinical note and then cognitively deduce, oh, well, this is where the physician was, what he or she was trying to say. When we do our education seminar, let's bring this point because I think this is the coding area that solution that might help him. We sometimes have lost that because we're reading through all this poundage and data and inconsistency that we can't follow the doctor's clinical thinking on paper. And so we can only imagine where that's going to then affect patient care and eventually open up for malpractice issues. and let alone just non-compliance to the evaluation and management coding guidelines. So the key thing about documentation is that it's always about patient care. The medical record is first and foremost a medical document, and with it being a medical document, it needs to comply to be a legal business document. Okay? Documentation rooted in medical necessity will drive the coding. And we basically try to strive that to the physicians. Now, we understand in a teaching hospital environment, we're going to see these comprehensive history and physical because first and foremost, we understand that the attending is teaching the resident, and the resident needs, and the med student needs to show to the chief resident that he or she knows what he or she is learning and has absorbed. But we always say that whatever is eventually documented in the assessment plan of care drives the level of coding, because what physicians should do is do what they do best, provide the highest possible level of patient care and document accurately the cognitive work associated with that care. So basically what the physician, we always say whether it's the physician or nurse practitioner or physician assistant, is let the exam be clinically relevant to why the patient is here. There are some problems that are pretty straightforward, acute, uncomplicated type of problems, versus something that's more systemic, like a GI, or a cardiac issue. So what he or she documents in that history portion of the note drives the overall level. Okay, and basically, as most of the malpractice attorneys will say, that thinking on paper will help substantiate why he or she chose that particular treatment option and substantiating it. So it becomes like the best documentation from a medical, legal, and coding perspective. Again, it's a complete circle. So we basically encourage clinicians, completeness in their documentation to also ensure that continued quality of care. So the one thing that I found that was very interesting was in the April 2008 a study published in the New England Journal of Medicine reported these similar problems, pointing out that notes that are meant to be focused and selective have become voluminous and templated, distracting from the key cognitive work of providing care. Such charts may satisfy the demand of third-party payers, but they are the product of a word processor, not a physician's thoughtful review and analysis. They may be efficient for the purpose of documentation, but not for creative clinical thinking. Now, what we say to the providers is that the EMR is designed appropriately and meets all the legal definition of a valid EMR, valid document, and if it meets some of the minimum documentation requirements, does not have to be voluminous and ineffective. It can be if it's designed so that it allows for free-forming, unstructured text to allow for that creative clinical thinking. So really, it's the education of the physician in using a flexible designed EMR that will make it more valuable. So there needs to be that investment in the education and the review with legal and in coordination with their healthcare IT person to make sure that the EMR meets the definition of a legal document and also some of the anti-kickback and Stark issues and the fraud and abuse issues that surface. So most often, what we see is that the attorney sometimes is overlooked as being a key participant in the planning process of that EMR. And there are a lot of anti-fraud and abuse requirements that are overlooked in the design and use of the EMR. So the the same American Medical Association, or AMA, and CMS documentation guidelines and regulations that apply for written and dictated notes are the same ones that apply to electronic medical records. So that kind of crossover is something that we drive home that physicians tend to overlook. If it's not there are certain things that a physician must document versus a med student versus a resident. There are certain things that you need to notate if your nurse is documenting the vitals versus you. There are certain things you need to do to authenticate you as the author of the note versus a scribe. So what we see is most often the lack of some of these documentation principles and authorship issues, which I'm going to be discussing next, that are lacking in the EMR design and somehow get lost in the translation because, we hear unfortunately comments, well, they're not going to recognize a different handwriting, so it's all going to be done by med student residents, and I'm not going to redocument, and I'm just going to sign my note. And they're not going to be able to tell because it's just all typed or it's dictated. So we all, we can all appreciate where that can lead a physician. So these are the things that they need to still comply. And in a well-designed EMR with multiple signatures and appropriate amendments and appropriate protocols to make sure that it's a legal document, these are some of the, this is what can help prevent the voluminous note or assure that the doctor is just clinically documenting what he or she is addressing at that encounter. So there are certain best practice and documentation requirements that now exist for computer application of EMRs, such as the copy-paste functionality and templates. And what some organizations have done, and they're wise to review some of these operational policies and procedures with their healthcare attorney on what they can copy and paste and bring forward. Is it just an active medication list? Do you really want to make sure that they have full range to copy and paste so much from the previous encounters? What if that diagnosis or condition has been resolved and the patient no longer has it? Are you going to have HIPAA violations in tagging a patient with a condition that he or she doesn't have? Is it no longer, or do you have a malpractice issue because you're saying it's resolved but you brought it over, and then the question becomes, why didn't you treat it? So there's copy-paste functionalities and best practice should be reviewed. And so they do need, we always say to the providers, they do need to be careful and vigilant when using them. So although it is inviting to let templates do much of the heavy lifting, providers need to be cognizant of the information contained within them and not blindly follow templates. And, AHIMA has some great cases documented, especially in the hospital with residents, where one resident followed another resident's note and data that was copied forward that was incorrect. It was a misdiagnosis that the attending caught, but it was never, the attending never actively addressed it on the current note, and the patient eventually died because they were treated for a condition that the resident assessed and not the accurate condition that the attending assessed. So, again, this copy-paste functionality can open up a lot of malpractice issues as well. So some of the red flags that we see as auditors and that the OIG has brought into play are the same wording being used for all patients for the history and exam elements with little or no change. And that the history and exam are comprehensive for all patients regardless of the regard to the medical necessity. So what I mean here is, if you find a patient who's coming in with the flu or bronchitis or sinus infection or heartburn, depending on what the patient is coming in for, is there really a need for such a detailed, comprehensive H&P? Now, one may argue that may be the physician's clinical style or he's in a teaching environment. That's fine. But then, in regard to the plan of care, if you're basically going to if this is a repeat sinus infection and you're prescribing antibiotics, in coding, there are levels, levels 1 through 5, 5 being the highest, in terms of the severity of the case. Well, does it really warrant you coding it at high level when basically the medical decision making is low or has low complexity, and it should be a 3, for example? So in the bell curve of the coding, the nature of the presenting problem, that's your best barometer in terms of the objectivity in determining medical necessity. And I know that there are those who argue who defines medical necessity. At this point in time, from a coding perspective, the medical decision-making and what the doctor cognitively documents in the plan of care is our objective measure in being able to support the code that a physician has selected for billing. And, like I said, some referring physicians complain about the canned EHR chart, and we talked about this. The routine nature invalidates the credibility because, like I said, if there's boilerplate history and exam for all patients and there's lack of customized, and, the customized templates, it raises the flags on 2 points. Not only does it raise a flag in terms of the clinical relevance, because remember, another physician or colleague reading it, what a physician documents in that history and exam is the documented cognitive thought processes of that provider in arriving at that differential diagnoses, and that's what helps that continuity of care to hopefully minimize malpractice occurrences. But then it raises a flag from the OIG standpoint and saying, God, there's no uniqueness. Is it really medically necessary to see this patient once a month or to this level of frequency? Where's the need or that customization or that uniqueness to document this episodic care in terms of, is it really clinically necessary to see this patient that often? Let me see your thought process. And that's some of the issues that we're seeing in terms of not just the coding for that encounter and the integrity of that documentation for that encounter, but the entire episodic care for that patient and those repeat visits and the rationale for ordering some of these diagnostic studies is that there isn't that triage and that decision tree as to what's going on with this patient to substantiate and warrant why you're continuing in this particular path. The cloning process, as we mentioned, creates a verbose chart note that's not reader friendly. And these rote responses don't necessarily call out pertinent positives. So with these exploding notes, as I mentioned, positive findings are embedded in a string of negatives, and these can be easily missed. And lists of negative findings can appear neatly with the push of a button. And we saw that in a cardiac case where, the patient's complaining with edema and swelling in the lower extremities, but in the history portion, it said no chest pain, shortness of breath, no edema. So there's the inconsistency in the history versus the physical exam, because while the patient did not have any chest pains or shortness of breath, the EMR, he clicked the pertinent normals, and it also put a check mark in no edema. So again, not only does it invalidate the clinical accuracy and relevance, but it opens up into fraud and abuse. He didn't really document and ask that, and we can see the malpractice potential in the making here if that is not corrected. So we say to the physicians, don't have an EMR that auto-populates, but really look at what you're signing, okay? Because, again, the EMR note should essentially mirror what your handwritten notes look like, only legible. And it should be, if I may add, intelligible. So one of the things that AHIMA put out is that to all healthcare community, that the EHR users should not expect unintentional deception or misrepresentation to be viewed more gently by payers, evaluators, or litigators. However, one of the many changes in the HIPAA legislation rendered is that the standard is now known or should have known. So this shifted the burden significantly by including the concept that those submitting the claims have a due diligence obligation to proactively identify and prevent fraud, as the burden now is that the deception nor the misrepresentation need not be known or intentional but should have been known. So all the more reason that when we go and we provide education, or after we're done our audits, we definitely highly recommend, hey, run your operational procedures, run your EMR IT standards by your healthcare attorney. Make sure that the design of the system will help the doctors, because the doctors are, while they're signing, they're very, they're very busy. There's a demand to see more and more patients in a given day, and he or she is focused in on, their thought is they're very dogged in their attention span. They're just focusing in on the clinical care, which is what it should be, and they rely on all these other tools to help them. And that's the key thing that we emphasize. They are not to be absolute, umbilical cord users. These EMRs are just tools. And so with that, as most entities migrate to an electronic medical record, we stress, get your healthcare attorney involved. Because one of the things that we try to say to them is, hey, when you're shopping for it, is it a legal, EMR? And I'm jumping slightly ahead, but, how well does the system show authorship? Does it clearly show who entered what portion of the record? That's our issue. Okay? How does it deal with the changes? Does it track alterations to the record, as well as who made the change? Does it save the original? How does the system's audit function support the accuracy and validity of the record? Are there cross-checks in place? So these are things that they need to get down in order to ensure that it is valid. And I think that most practices, what we see is, they forget that while they're meeting the documentation requirements for Medicare and the third-party payers and accrediting bodies such as JCO, they forget that the federal rules of civil procedure, basically has well-established rules for many years in, what are the universal set of rules that apply to all business records. And I think that sometimes the physician forgets that the medical record falls into that area. And as some of you may know, the new electronic discovery civil rule, which took effect December 1st, 2006, definitely affects the guidelines for maintaining the validity of the EMR. So these new rules present an opportunity for, the health information management professionals to collaborate with legal in the development of these operating policies and procedures to make sure that not only do their systems conform to these federal regulations, but to the given state regulations. And we always say, hey, there's also the fraud and abuse requirements for the EMR. There are, I don't think that a lot of times these practices or entities understand that they need to make sure they manage the Stark and anti-kickback law and the data privacy issues. For example, there are certain terms that must be documented to satisfy the IT exception under the Stark and anti-kickback. So basically, it's incumbent with these practices to work with payers, pharmacies, and labs in order to document some specific guidelines in their contract. And these laws have greater, confidence, in what they're doing. So we always say, talk to an attorney to make sure that some of these, practices are put in place. And if you have to take a stair-step approach to introducing technology, because all along the way you're reviewing them with legal, that basically helps us because we find the parallel in authorship issues The same with what we look at as auditors when we're trying to test the validity of the electronic medical record to the physician or to whoever truly documented that care. So at this point, I'm going to ask that you use the chat or the Q&A feature found on the right-hand side of the screen to submit any questions, and I'll wait a bit, and if not, then I'll continue on with authorship.
Okay, great. Thank you, Mary. We do have a couple questions here, and like Mary said, all those in attendance, please feel free to submit your questions via the chat or the Q&A. Mary, going back to one of your first couple slides here, of the 4 areas of concern that you mentioned, document integrity, authorship, auditing integrity, and patient ID, which of those 4 do you see causing the most problems, or where do you see, I guess, the most problems of those 4?
We see it predominantly from our viewpoint in documentation integrity and authorship. We see it in the documentation integrity because we see the clinical disconnect, and we see data being brought over that has no relevance to the encounter. So the same credibility issues and whether that a specialist may have, we have. And we also see the authorship issues. Medicare has clear guidelines in the PATH guidelines, the teaching physician guidelines. That's what got the University of Pennsylvania in trouble with the incorrect application of the PATH guidelines, physician at teaching hospitals. And there are certain requirements for a physician if he or she is going to borrow any entries made by the resident and or med student. There's only a certain portion of the documentation that a doctor can take from a med student. If they're going to use the resident's note, there's a certain attestation that needs to be done. With an EMR, we see that the med student may be documenting the entire note and the doctor is signing off, and there's no attestation or authorship as to was it a med student? What portion of the note did the med student really did document? Did the med student document the exam or just a portion of the interval history that he or she's allowed? So, we see issues with authorship and documentation integrity.
Okay, excellent. Thank you. We have another question here that has to do with security of EMRs. Are there certain policies or procedures that should be followed for storing the EMRs and or sharing the EMRs, across specialties?
Yes. We always say to the clients, there are certain HIPAA security requirements. You have your own hospital and or entity requirements. So we always say check with your IT department to make sure that your security is in compliance with the HIPAA regulations. And we always say check with the attorney. The key thing as far as the other security is the password protection. There are entities where they say don't share your password. Don't say, oh, I'm Dr. Falbo, and I'm going to give my password so that you can go in and sign the note, even though I'm not here and it's just a resident. There are entities that have policies that if there's an abuse of sharing the password and there's an incorrect authorship, there are policies where that physician is terminated. And then there should also be multi-tiered passwording, because what your billing person can get in is different than what your nurse can get in versus somebody else across another entity. So AHIMA highly recommends a multi-tiered password system, and then there's certain security systems, and there should be certain authentication with the physician who's entering it. And the biggest thing that we caution physicians, and we're seeing that, is there's that trust factor. They'll say, they'll give the nurse their own password so that she can get in and get the information for the patient record with all good intention because they're triaging a patient call. But, so there's, it's just like anything else that we do internally here, what I do with my firm or what you may do in your law firm. Every 30 days you may change the password. So there are all those kind of cautions, and security breaches are very big, especially across other specialties for a HIPAA violation and for all the reasons I mentioned. So they're also key areas. And they're part of what I would, of the 4 areas, the auditing and the patient identification and the security and HIPAA. But we get involved more with the documentation and integrity because we're at the heart of the clinical record.
Okay, excellent. I don't see any other questions in the queue, so why don't we continue on with the presentation?
Great. Thank you, Matt. So with that, this is a great lead-in to the next one, which is authorship integrity. So we talked about a bit of the documentation, which is the heart and soul of what we do here. And we always provide this feedback. We do a lot of prophylactic compliance work under attorney-client, and quite a few attorneys and law firms call us, and we do it under the attorney-client, mainly because if we find a systemic error finding, then the counsel can, not only is the work product protected, as you all know, but then the attorney can advise the client appropriately as to their duty to refund and certain other compliance obligations. But most of what we do, we provide this kind of clinical foundation and feedback to the attorney, and together we collaborate because there's that synergy that, what we say, attorneys will say, gee, Mary, he or she may also be not only opening himself up to a compliance risk in terms of fraud and abuse, but there's a HIPAA component, there's an anti-kickback and START component that I wouldn't think about, and there's a malpractice component. So there's these multidimensional legal risks that always come into it. So with authorship, inaccurate representation of the author of the document. What do they have in place to ensure that it's a valid legal document should it ever get admitted into court or subpoenaed? Duplication of inapplicable information, inclusion of entries created by others without knowledge or consent by the doctor whose name is on the claim form. The copy, cut, and paste functionality that gets abused. We see that quite often. The Incident 2 requirements. Medicare has what's called an Incident 2 requirement that if you're utilizing a nurse practitioner and you want to bill under the doctor's name to get 100% versus 85% of the fee schedule, then Medicare says, well, you know what, they can't see the new patients unless you bill under their own and get 85. So, if you can identify that the note was done by the nurse practitioner or doctor, how do you know that you're in compliance with some of these basic documentation principles? We touched on the teaching physician. We touched on the check-off of normal and negative, with these exploding notes. So one method of healthcare fraud involves using unlicensed individuals to perform services while submitting the claims under the provider number or legitimate provider. We see this with the, chiropractors using massage therapists or acupuncturists. So it's just, there's caution on who you're using to document the note. Medicare has a scribe policy. If you're going to use a layperson to do it, then you need to say Mary Falbo, scribe for doctor, so-and-so, evidence that the doctor was there the entire time and you basically function as his human typewriter. So authorship is very key, and a lot of the EMR designs need to really take that into consideration. The cut and paste is something that we see, and we're starting to see improvements because as we provide, in 2012 we'll probably be going into year 2 of some of the EMR. A good bit of my firm's clients are on an EMR. So some of the areas that we pick up, the clients have been really receptive. That outside viewpoint and feedback they've taken to heart, and they made modification and have gone back to their EMR vendor. So I think in 2012, hopefully some of the newness and issues will have been flushed out. But the redundancy is a key area, and the notes are lengthened, and the errors accumulate, and we help them with formatting to kind of segregate useful information. Stuff that the doctors care about from the endless notes, where things are placed, to kind of help with the fact that there is that decreased confidence in the material, because the copy and pasting and cloning results in fairly similar entries, so that the doctor a specialist just has no faith in that H&T, because feels that it's a cloned H&T or history and physical from all the patients, because the problem lists never change and the exam never change. So it's important to keep in mind that too much replicated information makes the note less readable, credible, and actionable. I remember working with a hospitalist program, and there's an option called shadow audits, where when we try to help physicians with their coding, we may round with the physician, because while he or she may have asked the physician those particular questions, the physician may not document it. So by shadowing, we can help them say, you did this. So what we try to do is, it's not a matter of documenting a lot of things right, but more documenting the right things. Well, we saw this one physician with these little index cards in his lab coat, in his white coat, and we said, doctor, why are you referring to that? Just because this EMR is so useless. It's poundage of paper that I don't even know what the current problems are. So I round with all the patients, and I write the current problems, so as I'm rounding, I know what I'm really dealing with today. So you talk about how the EMR has become counterproductive in the use of good patient care. He had to resort to handwriting some of his current problems on his index card and putting it in his white coat. So these are things that, doctors need to realize, that documenting all this poundage of paper isn't going to help you support the higher code, okay? Because it's not about documenting a lot of things right. It's about documenting the right thing. And don't use the EMR as the umbilical cord to your coding. It is a tool. And we basically say to the physicians, empower yourself, okay? So basically, in terms of this coding, just in the beginning of this year, the Office of Inspector General raises these concerns, and some of the documentation, and this is on the OIG's website, was the concerns over the system upcoding selection, cloning of patient data on subsequent visits, and auto-population or auto-fill-ins. Well, I wasn't surprised to see that, because as clinicians we had that kind of same concerns for the reasons I mentioned today. So the audits have shown the electronic charts with data pulled forward with updates, without any updates by the physician. If you're going to bring an entry on an interval history that's relevant, the physician needs a date and sign as evidence of the review and the accuracy. Histories are auto-populated without evidence the work was actually performed, and the charts where the EMR or the EHR systems have upcoded based on history and exam without the need for medical necessity. So they're looking at this, 99214. Remember earlier I mentioned there's a curve, one being the lowest straightforward, like a rash, versus something that's 5, that do we need to send the patient to the ER. So 4 is moderate, it's up there. Well, this code is currently the most audited code due to the systematic upcoding of the EMR. So records are scrutinized for these common EMR issues, such as record coding, where every record has identical language and description, and where the record resembles bits and pieces of information rather than a complete history. Because remember, one of the basic fundamentals in the sentencing guidelines and the fraud and abuse guidelines is, and Social Security Act, is that, you can bill Medicare, you can bill these federal programs, but the service must be medically necessary. So the question becomes, if you have this kind of identical language and this whole pattern, are you hurting yourself in substantiating the need for these more frequent visits? Is medical necessity, is the need for that visit warranted? So these are some basic federal regulations that come into question when the note doesn't appear unique and customized to that particular patient. So the OIG has indicated that they will increase scrutiny on the documentation created by EMRs to identify fraudulent use of these systems, even if the fraudulent use is unintentional. We covered that. So again, what we basically say to a lot of our clients, get the attorney involved in the beginning. So, and the OIG said that they will specifically be looking at records for cloned documentation or records that contain excessive documentation that may not be medically necessary based on the patient's visit. Now, if the doctors are coding based on the plan of care, they're not coding all these 4s and 5s, but they're coding it as a 3. At that point, an attorney defending the doctor can say, listen, it's up to the physician's clinical discretion and autonomy to document what he or she feels he wants to do for patient care. So they're not over-coding or over-billing. Okay, so remember what I said earlier. The EMR, the medical record is first and foremost clinical. Yes, then you need to have, there's certain coding and compliance regulations that need to be met. So if the doctor is coding his services appropriately based on the nature of the presenting problem, but has this extensive H&P and shows this customization, then an attorney can defend them saying, listen, this is a physician's malpractice choice to be conservative, to be thorough in his documentation. He or she really did do it, and he's not overbilling. It's just, he's billing based on the problem. The fact that he just chose to be more comprehensive or detailed than his H&P is his clinical discretion. So the area that we see the OIG is that when these type of habits become abusive in terms of upcoding or billing for higher levels without the supporting documentation for the service rendered. So the copy and paste does have its value to help the doctors be more efficient, in demographics and an active medication list and allergies and problems. You got to ensure the original author. It's inappropriate to keep on copying problems that are no longer active. Again, the HIPAA issue, copying medications that are no longer current. That's going to violate the meaningful use of the EMR. The upcoding that I just mentioned, and not identifying the author, okay? So if you're going to copy and paste and bring something back from a past record, was it something that your colleague documented? Was it his note or her note? Okay, so if you're going to bring something that's of relevant to you, then identify the author. Let that current note be a current summary abstract of that care, so that somebody in continuing that care doesn't have to go back through all these other previous records, and that continuity of care occurs without all these incorrect errors that we talked about earlier that led to a patient dying for treatment of a condition that he didn't have. So, cloning does have an impact on compliance and reimbursement. In a 2006 Medicare update, clone documentation does not meet medical necessity requirements for coverage due to lack of specific individual information. All documentation in the record must be specific to the patient and his or her situation at the time of the encounter. And Medicare then stated, cloning of documentation is considered a misrepresentation of the medical necessity requirement for coverage of services. And this is, I'm sure, not just a requirement with Medicare. If you look at the third-party payer contracts, I'm sure that, this is the same requirement in order to get paid. Okay? So identification of this type of documentation will lead to denials of services for lack of medical necessity and recoupment of overpayment. It's not just Medicare. Highmark Blue Cross Blue Shield and IBC are doing a lot of utilization reviews as part of the what I've seen occur after the Thomas Love settlement. So I've seen that these probe reviews increase after that. Whether it's in direct result of that, I don't know, but we saw that the pattern of utilization reviews occur shortly thereafter. So again, it's just not Medicare. So there's some best practices. So again, to summarize, I have about 2 more minutes, so please stay with me. All the information included in a note should have clinical relevance to the chief complaint, reason for the visit, and be pertinent to the care during that specific encounter. CMS and AMA documentation guidelines state that the documentation of each patient encounter should include relevant history, that's the operative word there, physical exam findings and prior diagnostic test results, and there's the link that basically supports that. Okay. Some of the legal concerns, because EMRs allow physicians to document easily, paragraphs of information can be generated with a few keystrokes. In the coordination of care activity between physicians, pages of repetitive documentation can be more time-consuming to review. And of course, overlooking important information is a significant cause of malpractice. And as with all other aspects of a physician's practice, they need to be careful and vigilant when using the EMR. So, in the auditing integrity, okay, there are certain addendums, amendments, corrections, and deletions that there are certain policies that have to occur when the doctor wants to add information, clarify information. So the audit trail should have that audit trail functionality to identify the original source. The auto-authentication, signing multiple documents at one time without opening them and or using scribes or assistants to make the changes falls short of federal and state authentication requirements and hence place physicians at legal risk. So late entries, okay, again, there are certain hospital policies that you need to follow the hospital and state policies. Typically it's within 24 hours. It has to be timely. So the EHRs are not standardized right now in functionality or structure as I opened up, meaning that there are hundreds of different software applications for creating electronic medical records. And many people are unaware of the lack of standards regarding the legality of the EHR. So this one, Barry Herron, a healthcare attorney with Smith Moore in Atlanta, said Medicare has requirements for medical records. JACO, the Joint Commission for the Health, has requirements for its accredited facilities, and each state has different rules regarding medical records. Medical staff bylaws may have its own set of standards. Depending on who you are and where you're located, you may have a variety of legal requirements for your EHRs to meet. Attestation is the main issue surrounding the legality of an EHR. An audit trail can often establish the legality of the EHR. So while most of the EHRs on the market can't produce a legally defensive health record because they don't track where people access and modify, there's technologies have started to alter the discussions. And in the past, healthcare providers had exclusive ownership of a patient's paper medical record. However, state and federal regulations are beginning to grant patients greater rights to access and modify their health records. So that opens a lot of legal advice to physicians and clients when a patient needs to do that. So that's really important to keep in mind. So there's some final thoughts here. When we conclude, we say, how original is your EMR? Does it promote quality of care and meaningful documentation? Remember, the EMR note should essentially mirror what handwritten note looks like, only legible. So as the healthcare reimbursement shifts from activity to outcomes, reporting quality outcomes and data transparency will become an important business requirement. So again, all information should have clinical relevance to the chief complaint and be pertinent to the care. And the use of copy and paste functions to be used as the exception versus the standard. And I read the American Medical Association has a brief on making an electronic medical record legal, and it says electronic medical records presented as evidence in court must have certain attributes. The record must be documented and kept in the normal course of business. The record has to be made at or near the time of the exam or event recorded. We saw that most of the hospitals have that 24-hour requirement. The record has to be made by a person with knowledge of the events. We talked about the authorship issues today. And when dictated, the physician must review the report for accuracy and authenticate it. The computer used must be considered standard and efficient equipment. Authors and sources of information must be identified. We talked about that if there's going to be the copy-paste, the addendum, the correction, the addition, late entries. Alterations must be noted and the original record preserved. And authors must be able to display the quality checks and audits. That's the audit integrity check used to identify data integrity. So you're seeing the parallels and similarity to what we look for, and that's what the OIG is trying to promote. So, again, the EMRs are inevitable. And I think it's like I said, failure to implement by 2014 may even result in increased malpractice premiums as well as reduction in Medicare reimbursement beginning in 2015. So, again, if it's not documented, it didn't happen, but now just because it's legible doesn't mean it is intelligible. So it's really important that the planning and the implementation of the EMR is communicated to your client, the legal ramifications, the understanding of everything that we just talked about, plagiarism, authorship, data integrity, legal risks. And the sources that I have listed here are the supporting sources for my presentation today, and I find AHIMA an invaluable resource. And again, the AMA has information there. So with that, I'm going to open up to any last questions that may have come in as I conclude my presentation today. And I thank you for your patience in staying with me.
Okay, thank you, Mary. A whole lot of information in your presentation. And thank you for the time and attention that you put into this program, because I think it really showed. We do have a question here from Asma, who asked, what would be the primary things a software vendor providing EHRs should be concerned with?
A software vendor? One of the things, as I mentioned earlier, is that looking to see that they are CCHIT certified, and that's that CCHIT, because in order to get that certification, that to me is, I now say to my physician clients and healthcare attorneys that ask me, if it's not a vendor that has that CCHIT certification run, because, we talked about the authorship issues. That's the main area of concern. And vendors that meet that CCHIT certification address these authorship issues. Again, because when amendments are made in their software programming, it has the audit trail that dates and provides the specifics of when that amendment occurred and what was amended. So it's authorship and making sure that these vendors have that CCHIT certification.
Okay, excellent. Thank you. I don't see any other questions in the queue, so we will wrap up this afternoon's program. Again, Mary, thank you for the time and attention that you put into this program. You can really tell that you're passionate about this subject, so thank you.
Thank you very much.
Everyone on the line, if you'd like to speak with Mary about a case, you can contact us here at TASA. Our telephone number is 800-523-2319. We'll be sending out a link to the archived recording of this webinar tomorrow morning. And the archived recording of this webinar, along with all of our previous webinars, are posted in the TASA Knowledge Center. You can find that by going to our website, tasanet.com, clicking on Knowledge Center at the top of the page. If you have any follow-up questions or comments, we do take all your comments in and use them to make our programs better. Please feel free to send me an email, mhyde@tasanet.com. You will be receiving a follow-up email from me today at 3:30. You can just respond to that email. Otherwise, we look forward to seeing you at future TASA events. I'm going to end today's program.
Thank you.